Well, hello, everybody, and welcome back to the radio show that features entrepreneurship and stories of entrepreneurship, and that is Radio Entrepreneurs. My name is Jeffrey Davis. I'm the host, and every week we like to check in with Mark Furman, partner and shareholder at the law firm Tarlow, Hart Rodgers for entrepreneurship and the law. Welcome back, Mark.
Hello, Jeffrey. Very nice to see you again.
You too, as well.
Jeffrey, I thought maybe we'd have a quick update on the Kane's Donuts situation. This is a family feud that we've talked about before. And by way of background, Paul Delios, the president and CEO of Kane's Donuts, has sued his four siblings. And
Right.
He alleges that they are freezing him out of the business despite his wonderful performance leading the company. And that lawsuit remains pending. He's sued for money damages and other relief and seeks to maintain current management and ownership structure. The parties apparently have been engaged in some type of discussions, I assume settlement discussions, and as of the recent past, even though the suit was filed in March, no answer had been filed to the complaint. Always a concern when the partners in a small privately owned business get into a fight, dangerous for the business. And when you have it's a family dispute, then the emotions get ratcheted up even more, and the threat is great. So that case is pending. And then in the meantime, the kind of new information is that there's another lawsuit, this one brought by a business partner, alleging that the company has not honored an arbitration award that was entered in favor of a company called John Doe, Dough LLC, which owns 30% of Kane's downtown Boston store at 90 Oliver Street, according to its complaint. Kane's owns the other 70%, and the arbitration apparently had to do with a variety of disputes, but some relating to the Route 1 in Saugus store. There was apparently some sort of a partnership agreement entered into in 2014 and an arbitration entered in 2021 that ultimately came down in favor of John Doe's. And there's an allegation that the Kane's has not fully complied with the arbitration award. So Kane has responded that they intend to, and they're just working out some of the logistics to do it. But I thought it brought up the issue of arbitration as well. That's worth chatting about briefly. You know, arbitration.
I assume you're going to do this. Arbitration is the equivalent of a judge's decision, correct?
It is, but in order for there to be an arbitration between private businesses and disputes like this, there must be an agreement to arbitrate. It's nothing that anybody can be forced to do. It's an alternative way to resolve disputes that is considered to be faster and less expensive than a full-blown litigation. So it's pretty common that parties, businesses agree to enter into arbitration as part of, in the event there's any dispute that arises in the future. Now, this is to be different. Also, arbitration gets used by businesses to try to force customers to go to arbitration instead of litigation. And businesses sometimes use arbitration clauses to force customers to agree to not file a class action, that every suit will be decided individually in an arbitration procedure. And there's a lot of litigation about that. But in the Kane's John Doe's situation, we're talking about an arbitration agreement between two businesses, how to resolve disputes. And in general, it is faster and it costs less. The downside is if the arbitrators make a mistake, there's almost no recourse. It's fine. So sometimes parties are comfortable with that and sometimes they're not. And perhaps in general, the higher the stakes, the less comfortable people are not having recourse. But there's exceptions to that rule. There's also, arbitration also creates a greater opportunity for confidentiality in terms of what goes on there. The courts are public proceedings, so everybody can see them. Everybody can look at the papers. Arbitration is a private dispute resolution, and it's administered by a third party. It could be a retired judge, a lawyer. It's sometimes it's one arbitrator, sometimes it's three, depending on how much is in controversy. So I think it's an important option for business owners to consider. But if you're thinking about wanting to have arbitration, the easiest time to think about it is if you want to impose it, make sure your agreements with your suppliers, your vendors, provide for it. Once the dispute erupts, now it's not going to happen unless both sides agree. And I would say it's more challenging to get both sides to agree because somebody feels they have an upper hand by delaying the process or making the process more drawn out or expensive. The playing field isn't always level in business disputes, so you got to think about it ahead of time. And the related concept is mediation, if I could just throw that out here for a moment, Jeffrey, which is different than arbitration. It's the parties, which sometimes happens in contracts, they agree to sit down and mediate a dispute, and which is totally voluntary. It's not a question of a third party imposing a decision like a judge would, making the decision who wins, who loses, and in what amount. But in a mediation, there's a facilitator, a trained mediator who tries to bridge the gap between the parties' position, whether it's the dispute between Paul Delios and his siblings in the Kane's Donut situation, or it's a dispute between John Doe LLC and Kane's Donuts about their partnership agreement. Mediation is an important option because, I've handled many mediations. I've handled many arbitrations, but my settlement rate in mediation is pretty high, I think, maybe 75 to 80%, and it saves a ton of money in litigation costs if there is a way to settle the case.
Well, I was, and we don't have a lot of time, but even if there's an arbitrator, and this is another wrinkle, they have to make decisions within the operating agreement if there is one as well. And that could be inconsistent from the case, couldn't it? So you have to, again, be careful about what operating agreements you sign, because that's the confines of how you have to make decisions, not just on the actions of what happened in the business. Is that
Right.
correct?
That is correct. But I think one of the negatives of arbitration, and I'm sort of a fan of it, but one of the negatives is if the arbitrator interprets the operating agreement incorrectly, is not much recourse. You're negotiating for the arbitrator's decision, as opposed to a judge. If it's an interpretation of a contract that is considered to be unambiguous, you get to take that to an appellate court to test whether or not the trial judge misinterpreted the agreement. And there are, believe it or not, cases where appellate courts overturn the interpretation of written agreements by a trial judge. From arbitration, you get finality, you get speed, you get savings of money in terms of litigation costs, but you also have a little bit more uncertainty in the result. I like to think when there's three arbitrators, you have a much greater chance of them getting it right. And I mean no disrespect to the arbitrators I know who are excellent
So
arbitrators.
you can do a team of arbitrators?
Yes, like certain companies that have arbitrators, they give you a right, if the dispute involves X or more dollars, to have three arbitrators rather than one. Obviously, you're paying for the arbitrators, so it certainly adds to the expense.
Still cheaper than a jury trial, I assume.
It is because the discovery is limited, and there's a little bit of a push to get to the hearing and get to a decision, as opposed to these long periods for discovery.
Well, again, in summary, I think too many of these entrepreneurs who I've dealt with and you've dealt with don't realize that the law and their operating agreements are more powerful than their personal will. And when they have to start to abide by those rules, it can be very hard for entrepreneurs. We've been speaking with Mark Furman, Director, Shareholder at Tarlow, Hart Rodgers. This is Entrepreneurship and the Law. Very important topic. Mark, if someone's looking to stay out of this quagmire, how would they find you?
I can be reached at 617-218-2025 or at mfurman, Furman, at tbhr-law.com.
Thank you very much, Mark. This is Radio Entrepreneurs.